Imagine opening your mail to find a massive bill for a multi-million-dollar accident claim or hundreds of dollars in toll violations for a car you haven't driven in years. Terrifying, right? Welcome to The Explainer, everyone. Today we are tackling a huge issue, untangling the bureaucratic red tape of transferring a car title in California after a divorce. I want to start with a serious warning right out of the gate. If you do not resolve your car ownership issues post-divorce, the legal and financial consequences can literally be devastating. We're talking about being held legally liable for your ex-spouse's actions on the road, simply because your name was accidentally left on a piece of paper. But hey, don't worry, we've got you covered. In this explainer, we're going to walk through a complete, step-by-step guide filled with essential, practical info to help you navigate this whole process smoothly and securely. Here is our roadmap for today. We're looking at the DMV reality versus court orders, decoding your title, the paperwork checklist, clearing roadblocks like loans and X's, claiming tax and smog exemptions, and finally, your protection and final steps. Let's jump right in. Section 1. The DMV reality versus court orders. Okay, so to start us off, we really need to address a super common and frankly dangerous misconception. It's totally natural to assume that once the judge drops the gavel and your finalized divorce decree awards you the car, it's 100% yours, right? Well, asking that question reveals a massive administrative gap. You see, California is a community property state. That basically means assets acquired during a marriage are legally presumed to belong to both of you. So when the divorce is finalized, the court divides those assets. But, and this is the kicker, that court order does not magically update the state's DMV databases. It's like having a giant puzzle with one absolutely crucial piece missing. This setup brilliantly illustrates the divide. The family court decree simply dictates who gets the vehicle in the divorce settlement. The DMV reality, on the other hand, dictates who is legally and financially liable for the vehicle out there on the open road. Family court orders are not self-executing. Under California Vehicle Code Section 5600, you have to actively update the DMV within 10 days of the ownership change, just 10 days. If you don't, you remain legally anchored to your ex-spouse's liabilities. Moving on to Section 2, decoding your title. Now, what's really fascinating about this next step is that a single tiny word, or even just a punctuation mark, on your physical title dictates exactly how hard this whole process is going to be. Go ahead and check your title carefully. If you see the word "or" between your names, you have what's called alternative titling. That is the best case scenario because either one of you can transfer the title unilaterally. Super easy. But if there's an "and," or honestly even just a slash mark between your names, you've got conjunctive titling. This establishes a tenancy in common. The DMV is statutorily prohibited from processing the change without signatures from both of you. It acts as a total mutual veto. All right, Section 3, the paperwork checklist. Let's get down to the execution phase and cut right through that alphabet soup of DMV forms. If both you and your ex are cooperating, it's just a standard voluntary transfer. Basically, by following these 3 steps, you're acting as the buyer while your ex acts as the seller. First up, the spouse giving up the car has to sign line 1 on the front of the certificate of title. Second, the spouse keeping the car fills out Form Reg 343. That's the application for title or registration. And third, you'll both need Form Reg 256, the statement of facts. This form is where you explicitly tell the DMV, hey, this transfer is happening because of a divorce settlement. Submitting these 3 documents together gives the DMV the whole shebang, everything they need to formalize your transfer. Section 4, roadblocks. We're talking loans and uncooperative exes. But let's be real for a second. What if things aren't that simple? The crucial thing to remember is this. If your car is financed, you don't actually own it yet. The lien holder, which is usually your bank, is the legal owner. And under DMV rules, you cannot just remove a registered owner from a title without the bank's express written authorization. Plus, the family court literally cannot force a lender to alter their contract. If both you and your ex co-signs that loan, you're both financially on the hook. So to remove an ex from a title with a lien, the spouse keeping the car almost always has to fully refinance the debt entirely into their own name first. And what about the nightmare scenario? An ex-spouse who just flat out refuses to sign the paperwork? Well, take a look at this real-world case study from Tim Blankenship at Divorce 661. They help people navigate this exact issue. They had a client whose ex was totally stonewalling her, refusing to sign over the title. Because of that, she couldn't even update her insurance or registration. But they used this brilliant legal workaround under California Vehicle Code Section 5909. By submitting a certified copy of the divorce judgment directly to the DMV, they completely bypassed the ex. The court order effectively forced the DMV's hand. So how do we turn that into actionable advice? First off, if you have an uncooperative ex, you need to document everything. Every text, email, certified letter, keep it all. If you have to go back to court for a motion to compel, you need solid proof. Also, and this is absolutely crucial, make sure your judge's order lists the specific 17-digit VIN of the vehicle. If the decree just says the family car, the DMV is going to reject it. It just causes massive administrative gridlock. You should also ensure your court order mandates a strict 30 to 60-day timeline for refinancing any loans. Oh, and finally, if you're restoring your maiden name using Form NC-100 or through the divorce decree, update your legal name with the DMV at the exact same time you transfer the title. It saves you extra fees and a whole lot of hassle. Moving to Section 5, Tax Exemptions and Smog Rules. Now, I know slogging through all this red tape feels totally exhausting, but here is a massive financial silver lining. Usually, when a car changes hands in California, the buyer gets hit with a hefty use tax based on the car's value. Plus, they have to go get a smog certification. But because splitting community property is legally viewed as an involuntary transfer, you are beautifully exempt. As long as the current registration is active, you don't pay the use tax, and you don't need a new smog check. You literally just have to check the right box in Section B of Form Reg 256 to claim it. That alone is going to save you hundreds of dollars. Finally, Section 6, Protection and Final Steps. Okay, we are in the home stretch. Let's make sure you are legally protected and fully compliant moving forward. Think of this checklist as your ultimate shield. If you are the spouse giving up the car, do not, I repeat, do not wait for your ex to file the paperwork. You must immediately file Form Reg 138, the Notice of Transfer and Release of Liability, within 5 days of handing over the keys. This severs your liability if they go out and crash the car tomorrow. Now for the spouse keeping the car, verify your title change status online. Once it shows as processing, get on the phone and immediately update your auto insurance policy so it shows you as the sole owner. Also, make sure your registration and driver's license match your current legal name perfectly. Consistency here is going to prevent massive headaches later on. Now, a quick but important disclaimer. We've laid out a pretty comprehensive roadmap based on current California laws and DMV practices. But, as we all know, regulations can and do change over time. If you find yourself in a complex situation, especially one involving contested assets or really tricky auto loans, consulting a legal professional or reaching out directly to the DMV for advice tailored to your exact circumstances is always a very smart final step. I want to leave you with this final, provocative thought. A divorce is supposed to be a clean break, right? A fresh start. But have you truly severed the financial and legal ties of your past? Or is a single piece of paper sitting in some DMV database still anchoring you to your ex-spouse's liabilities? Don't let a simple administrative oversight ruin your fresh start. Take control of your assets, file the paperwork, and ensure your independence is legally airtight today. Thanks so much for joining me for this explainer, and I'll catch you next time.